RICO Act, rape, aggravated sodomy, trafficking a person for sexual servitude, aggravated assault with a deadly weapon, false imprisonment, pandering by compulsion, possession of cocaine, RICO Act, rape, aggravated sodomy, trafficking a person for sexual servitude, aggravated assault with a deadly weapon, false imprisonment, pandering by compulsion, possession of cocaine, tampering with evidence, willful obstruction of a law enforcement officer, and pimping as set forth in the indictment, and a true verdict give according to the evidence, so help you God. If so, please answer, I do. All right, thank you, ladies and gentlemen. You may be seated. Ladies and gentlemen, we are now ready to begin the trial of this case. I have some preliminary matters to discuss with you. I've already introduced my staff, and I encourage you to approach them if you have any questions. You will report to the hallway that you just came through next to courtroom 8C, and ring the buzzer always that says Judge Leftridge next to it. You will be buzzed into the hallway and you will proceed to my jury room. Ladies and gentlemen, from this point forward, you will not enter the courtroom unless Sergeant Pilgrim brings you out from the jury room. After breaks and at the beginning of the day, you will go straight to the jury room from the elevators. Please wear layered clothing. Sometimes it is cold in the jury room and in the courtroom. We have a refrigerator, a toaster oven, and a microwave available for your use. Please bring snacks and your lunch. Unfortunately, there are very little available food choices around this courthouse. I will ask that you wear your juror stickers whenever you are in the courthouse. This is so the lawyers and the witnesses can identify you as a juror. From this point on, the lawyers, parties, witnesses, and anyone else associated with this case in any way, with the exception of my staff, are prohibited from having any contact with you whatsoever. So if you happen to encounter any such persons on the street or in the elevator, please do not attempt to communicate with them in any way, and do not be offended when they ignore you. They are not trying to be rude. They are simply abiding by the law. If for some reason you have contact with one of the lawyers, or if you inadvertently overhear something about the case, please notify my deputy immediately. Ladies and gentlemen, we will generally hold court from 9 o'clock until between 5 and 6:30 p.m. With a 1 hour break for lunch around the noon time, whatever makes sense. Sometimes it'll be 1 o'clock, sometimes it'll be noon. It just depends. For the sake of your fellow jurors, please arrive on time, as we cannot begin or continue the case until all jurors are present. If something unexpected happens and you absolutely cannot help being late, please call my office immediately. We will provide you with the number. You will reach out to Ms. Tomlinson, my judicial assistant. Again, you are not to discuss the case with anyone or allow anyone to discuss it in your presence. And I need to remind you not to watch TV or read newspaper accounts, no social media, no posting regarding the case. In other words, I'm not saying you can't watch TV, but if something were to pop up on the television related to this case, then you should immediately turn the channel, okay? Ladies and gentlemen, I believe it might be helpful if I give you some preliminary instructions concerning criminal law and trial procedure, which will apply to this criminal case. A crime is a violation of a statute of this state in which there shall be a union or joint operation of act and intention. That is, a crime is committed when a person violates a statute of this state by acting as prohibited, while at the same time he has a criminal intention and no other defense excuses the conduct. A person will not be presumed to act with criminal intention. However, you, the jury, may find such intention upon consideration of the words, conduct, demeanor, motive, and all other circumstances connected with the act for which the accused is being prosecuted. The state cannot bring a person accused of a felony to trial unless the grand jury has first indicted that person. Grand jurors do not try criminal cases. They ordinarily only hear from witnesses for the state. When a criminal case is tried, the defendant has pled not guilty to the indictment. This plea of not guilty denies every essential allegation of the indictment and forms the issue or question that you, as the trial jury, will decide.
I often joke that I'm retired, but in reality, it's just that I get to live my dream of being a full-time DJ. And that's because of my amazing business partner, Honeybook. Honeybook takes care of all the administrative work that I don't want to do so that I can get back to my passion. Honeybook makes it look like I'm a team of 10 when it's really just me in the background. Plus, Honeybook AI is woven all throughout the platform, giving me insights, drafting emails, and taking notes. And since it knows my business, it's doing all the work so that I don't have to. Get started for free at honeybook.com.
What if recording high quality content, editing like a pro, and streaming like a star was as simple as hitting record? With Riverside, it's just that. Riverside makes the entire process easy, from recording to editing to streaming without having to jump from app to app. Everything you need is all in one place. Recording is simple. Hit record to capture your live session locally, maintaining the highest quality recording while also creating separate audio and video tracks for each participant. And when it comes to streaming, it's never looked this good. Stream in HD with high quality video and audio customized with your logo, background, and color theme. Engage with your viewers easily through the centralized chat box, bringing everyone together across different social channels. Riverside's AI-enhanced editor lets you cut down on editing time. Use it to transform your recordings into high-quality, branded content. Get transcriptions automatically and use them to edit just like a doc, or use the chapter timeline where it's divided into chapters that make it easier to skim and scan. And when all's said and done, Riverside goes the extra mile to optimize your content for sharing. Add video captions in various styles, easily resize your videos for different channels. Plus, with more nifty AI features, Riverside helps you find and create your best clips, turning them into polished, viral content at the click of a button. So, ready to start creating? Try Riverside now for everything you need in a conversation studio for free.
The indictment and the plea of not guilty to it are the legal procedures by which the state brings charges against the accused into court. They are not evidence, and you should not consider them to be evidence. Every person is presumed innocent until proven guilty. No person shall be convicted of a crime unless each element of the crime is proven beyond a reasonable doubt. The state has the burden to prove each essential element of each crime charged beyond a reasonable doubt. In this state, a defendant on trial may or may not testify as he or she chooses. If the defendant does testify, you would judge his or her credibility by the same tests applied to any other witness. If the defendant does not testify, which is the defendant's absolute constitutional right, you shall not draw any inference of guilt from this decision, and the defendant's election not to testify may not in any way affect your verdict. Moreover, the defendant has no duty to call any witnesses or present any evidence during the trial. If he or she calls no witnesses or presents no evidence, you may not derive any inference of guilt from such failure to produce evidence. In such case, you decide guilt on whether the state's evidence proves the defendant guilty beyond a reasonable doubt. Under our system, I have the duty as the trial judge to decide the law that applies to a case and instruct you on it. You have the duty as the jury to decide the facts in a case from the evidence and reasonable inferences arising from the evidence. In reaching your verdict, you also have the duty to apply the law to those facts. You decide the facts from the evidence. The evidence has two parts: testimony of witnesses and exhibits. A witness means anyone who testifies in person from the stand. The exhibits are those documents, objects, or photos that the court admits into evidence. You will have most of the exhibits with you in the jury room while you deliberate. However, there are some exhibits which cannot be sent to the jury room, so it will be important that you pay close attention to all of the exhibits admitted during the trial. I caution you that what the lawyers say during the trial is not evidence. Also, anything I might do or say is not evidence. I have no leanings at all in this case. My only interest is to have the case tried fairly and according to the law and the constitutions of this state and the United States. You are the exclusive judges of the witnesses' credibility. That is, you decide the truthfulness and reasonableness of their testimony. You may believe or disbelieve all or any part of the testimony of any witness. You have the duty to decide what testimony is worthy of belief and what testimony is not worthy of belief. You should lay aside any preconceived notions and not decide a witness's credibility until the witness has testified. This is true no matter who the witness is, whether a victim of a crime, the defendant on trial, a police officer, an expert in some field, or otherwise. But remember that the defendant has no duty to testify or present any evidence.
Your workflow is important to us. Please wait indefinitely.
With Monday.com's intuitive work management platform, you have the power. Not IT, not admins. You're in charge. So you can tailor work exactly
Whatsoever. Rules of law. law govern what the court admits into evidence. If an attorney objects to the admission of evidence, then I must rule on the objection and decide whether you can consider the evidence. You should understand that there are two ways that I can respond to an objection. If I say sustained, then that means that I granted the objection and you should not consider the objected to evidence. If I say overruled, then that means that I did not grant the objection and you may consider the objected to evidence. You should not infer or assume anything from either the lawyer's objections or the court's rulings. During this trial, the court will have to consider some issues outside of your presence. When that occurs, I shall excuse you to the jury room for a time. During these periods, the court will do its best to handle the matter as promptly as the law permits. These interruptions, ladies and gentlemen, may occur frequently or infrequently. They may occur very close in time to one another or far apart from each other. They may last for what feels like a short period of time or a lengthy period of time. I wish for you to understand that this is a common occurrence and ask for your continued patience when this happens during the course of the trial. Now, the procedure in a criminal trial is generally as follows. First, the lawyers for both sides may make an opening statement to you. This opening statement is not evidence itself. Remember, what the lawyers say is not evidence. However, it is a preview or an outline of what they expect the evidence to show. Following the opening statements, the state has the opportunity to present evidence to support the charges against the defendants, and the defendants have the opportunity, if he or she so elect, to present evidence in his or her defense. This part of a trial is called each party's case in chief. In the state's case in chief, the state calls its witnesses and introduces any exhibits. When these witnesses testify, they may be cross-examined by the defendant. When the state has presented all of its evidence, the state will rest its case. Then, if the defendant elects to present any evidence, the defendants may call his or her witnesses and introduce his or her exhibits. Of course, when these witnesses testify, they may be cross-examined by the state. However, the defendant has no duty to testify or present any evidence whatsoever.
Restream's Upload and Stream is how podcasters, fashion and beauty streamers, fitness coaches, even business professionals grow their channels. Upload your video to Restream and we'll stream it live to YouTube, Facebook.
After the presentation of the evidence, the lawyers may make a closing argument to you. At this time, the lawyers will try to persuade you to decide the case in their favor. Following the closing arguments, I will charge or instruct you more specifically on the law that directly applies to this case. Then you will retire to the jury room to deliberate and reach your verdict. Ladies and gentlemen, this is not an exhaustive description of the procedure in a criminal trial, but hopefully it will give you a quick overview which will help you to understand the trial as it proceeds. It is your duty to follow any instructions that the court may give you during the case. Please remember to listen carefully to all of the evidence. Do not jump to conclusions before the parties present all the evidence. Also, please remember that during a trial, it would be improper for you to discuss the case with anyone or to allow anyone to discuss the case with you or in your presence or within your hearing. Also, during the trial, you should not communicate with the parties, their lawyers, or any of the witnesses or anyone else other than members of my staff. Under this rule, you should not engage in even social greetings or small talk with anyone involved with this case in any way. Again, please understand that the lawyers and the parties should not speak with you as the trial progresses and will likely avoid speaking with you to ensure there is no appearance of impropriety. These restrictions also apply to the friends and family members of interested parties. During this trial, the law will not require that you be kept together during breaks for meals or at night. When you return to the courthouse from any adjournment for meals or the night, please go directly to the jury room. This will lessen the opportunity for an accidental meeting with a person that you may not know is involved with the case. If there is any coverage of the case by newspaper, radio, television, or other media, you should be careful not to consider it. Do not independently investigate any facts or visit any scenes depicted in the evidence. Do not independently research any law concerning the case. For example, you are prohibited from doing any such independent investigation or research concerning a case on the internet. You've now received several specific instructions that make it clear that you cannot conduct independent research of the case and cannot communicate about the case by electronic devices or otherwise. I've said it repeatedly because it is important that the only evidence you consider is that which is produced within this courtroom. Please be careful to abide by the rules of the court. Ladies and gentlemen, to preserve the integrity of the jury room, the jury system, you as the finders of fact must decide this case solely upon evidence presented in this courtroom. This means that during the trial, you must not conduct any independent research about this case, the matters in the case, and the individuals involved in the case. In other words, you should not consult dictionaries or reference materials, search the internet websites or blogs, or use any other electronic tools to obtain information about this case or to help you to decide the case. I know that many of you use cell phones, iPads, computers, and other tools of technology, which are right at your fingertips. Please do not try to find out information from any source outside the confines of this courtroom, to include media of any sort or online legal research. Ladies and gentlemen, until you retire to deliberate, you may not discuss this case with anyone, even your fellow jurors. After you retire to deliberate, you may begin discussing the case with your fellow jurors, but you cannot discuss the case with anyone else until you have returned a verdict and the case is at an end. You also must not talk to anyone about this case or use tools to communicate electronically with anyone about the case. This includes your family and friends. You must not communicate with anyone about the case on your cell phone, through email, iPhone, text messaging, or on Twitter, through any blog or website, through any internet chat room, or by way of any other social networking websites, including Facebook, MySpace, LinkedIn, and YouTube. I've asked Sergeant Pilgrim to provide you with pencils and notepads for your use during the trial. You have those, is that correct? You may take notes, but you are not required to do so. If you decide to take notes, please remember that note-taking should not divert you from paying full attention to the evidence and evaluating witness credibility. Your observations of the witnesses during their testimony can be vital to your determination of the believability of their testimony. The notes that you take are for your use only and are not to be shared with anyone until you begin deliberation with your fellow jurors. Notes are not evidence, only memory aids, and should not take precedence over your recollection. It is the duty of each juror to recall the evidence, and while you may consider another juror's notes to refresh your memory, you should rely on your own recollection of the proceedings. Ladies and gentlemen, do not be influenced by the notes of other jurors unless their notes help you in determining your own independent recollection. Notes are not entitled to any greater weight than the recollection or impression of each juror as to what the evidence may have been. Ladies and gentlemen, after the trial is over, the notes will be collected and destroyed. That concludes my preliminary instructions, and now we are ready for the lawyers to offer you opening statements. On behalf of the state, is there a desire to offer this jury an opening statement?
Yes, Your Honor.
You have the floor to do so at this time, Ms. Winfrey.
Thank you.
You're welcome.
I wonder if Honeybook has any new leads for me today.
Prioritize leads with AI that gets your business. Let's work wonders.
What if you can create your own website by saying, this is what I want? With Wix, you can. First up, let's talk about AI color themes. You can get any combos you want, bold and bright, minimalist and sleek, or
Promises. Promises of love. Promises of safety. Promises of a better life. Promises to level up. Promises to lay your head down in a safe place. Promises, promises, promises. You will learn that there were promises given in this case. They were cloaked in profit, cloaked in greed. In their arrogance, predators target the weak who are caught in the schemes they devise. Their eyes watch in secret for their victims like rattlesnakes hidden in rocks. They lie in wait seeking to devour. Ladies and gentlemen of the jury, that is what this case is about. This case is about these defendants. These defendants who built a proverbial house, if you will, a business on the backs of young women through the lure of their leaders' notoriety. Good afternoon, my name is Ernell Winfrey. As I stated earlier, I, along with my co-counsel, Chief Deputy District Attorney Adrian Love, Deputy District Attorney Grant Wood, represent the state of Georgia. First, I want to thank you for your patience during the arduous task of jury selection, and I thank you in advance for your service today. As you see the evidence unfold in this case, you may see witnesses that may not be in chronological order. Don't be alarmed. Just stay with us to the very end. It will all make sense. The players. Who are the players? John Michael Hakeem Gibson, also known as Cash Out. You will learn that he is the leader of this organization. You heard the word enterprise. It's just a group of people doing criminal acts for money in this case. You will learn that he's the one who set up plays and dates through cell phones, who lured girls in through his notoriety, who promised love and other things to get them to comply, who then turned coercive toward the end. Linda Smith, also known as Malika Benny, also known as Mama Cash Out. You will learn that she is the mother of John Michael Gibson. And you will also learn all of her involvement, even including being a manager of sorts, even making clothes for girls to wear as they sold themselves. Tyrone Taylor, also known as Brewski, you will learn that he is a cousin of Cash Out, John Gibson, and you will learn of his involvement. He was like a recruiter. You'll learn that he was trying to be close to someone who's famous to meet somebody. You'll learn that he got involved with a young girl he never even knew before, with the promise of a safe place for her to lay her head. And you'll learn of his involvement with other witnesses in this case. The house that Cash built, literally and proverbially, it was built on exploitation, built on girls who were vulnerable. During the course of this trial, you will hear evidence about a criminal enterprise. Now that's a legal term. Don't get confused about that. Like I said, it's just a group of people committing crimes for profit. They organize themselves and they work together to do it. This organization works in the shadows, but it also works in plain sight. They built it by exploiting others, exploiting young women, fueled by deception and coercion, especially young women. Driven by profit and greed, orchestrated by each of them. It was a criminal conspiracy that preyed on vulnerable young women for the purpose of making money. This case is about manipulation. It's about control, mental manipulation. It's about isolation. This case is also about violence. Now, you've heard at the beginning of the trial all these different counts. You've heard racketeering, you've heard RICO. RICO is just a pattern that we're going to show that they use to do these criminal acts. Several criminal acts they use to advance their organization to make money. The evidence will show that they operated in a group. You will hear about trafficking a person for sexual service. You hear about pimping, pandering, tampering with evidence, obstruction. All of these criminal acts operate in concert to show that they operated together. That's all RICO is. You will hear from survivors, women who were groomed, women who were isolated and sold. You will see records and messages, financial transactions, witness testimony, victim testimony, all calculated and designed to profit off of human suffering. You will also hear from expert witnesses in this case. Specifically, you will hear from an expert witness whose name is Mary Beth Nelson. She is a witness of human trafficking, and she will give you education and provide the dynamics of sex trafficking and debunk the big myths about trafficking. She'll debunk the myth about sex trafficking being the proverbial white man that runs around and snatches women and children off the street and sells them into sex slavery. She'll talk about it being up close and personal and intimate. She'll explain to you the nomenclature or the verbiage used in commercial sex so you'll understand when the evidence comes out what is being said and what it means. You'll hear from DNA experts, and it's up to you to judge the credibility and the believability of all the witnesses, to include DNA experts, and they will provide their findings.
Struggling with complicated content and editing software? I was too. Riverside really simplified things. Riverside makes the entire process easy, from recording to editing to streaming without having to jump from app to app. Everything you need is all in one place. Recording is simple. Hit record to capture your live session locally, maintaining the highest quality recording while also creating separate audio and video tracks for each participant. Riverside's AI-enhanced editor lets you cut down on editing time. Use it to transform your recordings into high-quality.
So, who are we really talking about here? This case centers around victims. And you heard many names at the beginning of the initial questioning when you all were sitting in the general audience. You will learn about Jasmine Brown. You will learn that she's from Delaware, was a ward up the state, meaning she didn't have a connected family. You will learn that her first play was a violent rape set up by her trafficker, John Michael Hakeem Gibson. You will learn that she ended up getting out of that situation by some brave law enforcement folks who stepped in and saw her and helped her get out. And it was from her disclosure that all the drug homes were able to find other survivors and victims to bring these defendants to justice. You will learn about Jordan Adams, who was also a vulnerable young woman who had gotten kicked out of her home and was on the streets of Atlanta. She ran into Tyrone Taylor, also known as Brewski, who promised her a safe place to lay her head that night at a hotel on Hilton Industrial Boulevard. Unbeknownst to her, she's raped and she is sodomized. You will learn that Mr. Taylor, defendant Taylor, he invited Cash Out over to have fun with her as well, and she was victimized all night long. You will learn she was also then put out on the street to go and sell herself. You will learn about Jessica McQuarrie, who is from Indiana, and she was involved with Cash Out during the early years. Dominique Lewis-House, you'll learn about her. Talicia Doolittle, Frederica Spencer, Talithia Wright, Shantori Tolbert, Diamond Irvin. You will learn that while each of them found themselves in this heinous situation, The one common thread is that while they suffered, they survived. They were robbed of their dignity and cloaked in shame. We will show that the defendants in this case used threats of harm, physical harm, psychological abuse, financial control, and drugs to trap their victims. And we will demonstrate that this organized group had a command structure, specific roles, specific rules, but the product in this case was human beings. Human beings used over and over and over again. You will learn how Cash Out and his mother, Mama Cash Out, and the cousin Brewski, this is all in the family, and how they work together in order to obtain this goal. This goal was to make money, motivated by money. The enterprise, it used tactics designed to recruit women, designed to control women, designed to exploit young women. Some of these women were often desperate. For the purpose of commercial sex, this is what they were obtained for. They lured them through a pattern of systematic plans, all of this again to gain money. The victims were groomed, isolated from their families, and coerced. And the people sitting behind this operation, they knew exactly what they were doing. The house that they built, the foundation is greed. The backs of the young women that made the money for them, they had no control of the money. Some of them subject to sexual violence, some of them subject to physical violence, all of them subject to psychological violence. Now, there's something important you will hear in this program. Two of the co-defendants, individuals who were once part of this very enterprise, will take the stand and they will testify for the prosecution. They will tell you what they saw. They will tell you what they did. And they will tell you what these defendants did. The witnesses were not promised anything in return, no bills, no promises, no favors. They are coming forward because the truth matters. And because they know what happened, they know it must be brought to the light. Their testimony will be of Kiera Adams. You will learn that she's been involved with Cash Out from even early on, since about 2014 to about 2022. Intimately involved with the inner workings and dealings of this organized way of committing crimes. She will describe in detail all that she did, her part in it, and all that they did, and their part in it. You will also hear from Deanna Sanders. She was in a relationship with Cash Out. And you will learn that all of these girls believed that they were in a relationship with Cash Out. All of them learned and felt as though he loved them, or they were his girlfriend, or they were his wife, or soon to be wife. All of that. And Deanna Sanders will talk to you about her physical abuse at the hands of this woman. You will have corroboration. You will have the testimony will be supported by a mountain of evidence, text messages, financial records, witness accounts, victim testimony, all of it pointing to the same conclusion. The defendants worked together, exploiting human lives for profit. Now, the court already instructed the burden is on us, it's on the state. The defendants have no burden whatsoever. They don't have to put up a scintilla of evidence at all. But I want to inform you to be mindful of the distractions, to not go down the rabbit holes. The evidence will be the evidence. I ask you to take notes, copious notes. We'll be here for a while. So you may not remember something from the first day to the last day. This evidence will be disturbing. I will admit the details will be hard to listen to and difficult, but they are necessary. Because at the end of this trial, the only conclusion the evidence will support is that the defendants ran a criminal enterprise that trafficked human beings. Defendants Taylor and defendants Gibson even sodomized and raped one of the victims. And this pattern of criminal behavior must be brought to light. and the defendants must be held accountable. You will learn that there is nothing that is concealed that will not be disclosed or hidden, and that all will be made known. What has been done and said in the dark will be heard in the daylight, and what has been whispered in the ear in the inner rooms will be proclaimed from this witness stand. I will come back to you at the end of this case, and we will talk about all the evidence you heard, and we'll review all the applicable law. And I will come back and ask you to find all of the defendants guilty. Thank you for your attention.
All right. Mr. Matthews, on behalf of Mr. Gibson, would you like to offer this jury an opening statement?
Yes, Your Honor.
You have the floor to do so at this time, sir.
Thank you. Ladies and gentlemen, good afternoon. I want to take this opportunity to thank you in advance for your time and your attention that you have given to us for these last 7 or 8 days and getting you all selected. We have selected the jury that is the fairest jury to hear this case. I have an opportunity and a privilege and an honor to represent Mr. John Michael Gibson, along with myself and Attorney Carson Matthews Jr. You have been impaneled, ladies and gentlemen, to hear and listen to evidence and law in this case. The trial of John Michael Gibson, aka Cash Out. Who is John Michael Gibson? He's 34 years old. He's an American rapper. He was born in Columbus, Georgia. He moved to the Atlanta area as a teen. Came from humble beginnings. He moved to Atlanta, Georgia, living with his mother and his siblings, east side of Atlanta, and he developed a love for music. He worked hard in the development of his craft. He didn't allow his humble beginnings, he did not allow where he was born, he did not allow his circumstances to stop his dreams. What were his dreams, ladies and gentlemen? His dreams were to write music, to write lyrics, become an artist, sell records, to do concerts. Through his hard work, through his dedication, through his sacrifice, that came to fruition. He went in the studio, right here in the Atlanta area, started working, started putting his talents to work, putting his hard work and his sacrifice to effort. And that effort began to pay off. So he's 21 years old when music executive L.A. Reid invited him to New York City, along with his local management, to be signed. Mr. Gibson, he performed for L.A. Reid up in New York City. When he performed for them, they spent the entire day talking in a boardroom with industry executives. And they signed John Michael Gibson, Cash Out, Epic Records. When they signed Mr. Gibson, his first major song was a song by the name of Cash It Out. It was released in March 2012. It peaked at number 36 on the Billboard Hot 100. It was runner-up in the hip hop department, and it topped as hot rap songs. Mr. Gibson toured all over the nation, every city.
Great content needs a great audience, like Stretch Armstrong needs to be stretched. Yeah! Woo! Feel the stretch? With TubeBuddy, you get everything you need to grow your audience. Click the link to sign up. Always practice safe stretch.
Every state. He was famous, and still is. He was known. His songs were being played all summer long, all year long. And he did well for himself. He didn't just stop with making that one single. He made another single, released it in 2012, featuring Wale. He made another single in 2012 called She's Working. These are songs that were played everywhere. Single released in 2014, Still Working. Released an album in 2014, Let's Get It. Features with Wiz Khalifa, Ty Dolla, French Montana, Rich Homie Quan, Waka Flocka. These are not just local artists, these are national artists that Mr. Gibson was working with and worked with. These are 12 tracks. This is a full album, working. These songs aren't making themselves. Released another album in 2014, featuring Snoop Dogg, Rich the Kid, DJ Bobby Black. He worked with these artists. In November 2014, released another album at 11 tracks. 2014, another album, It's My Time. Keisha, another one, 2015, 17 tracks. Working, honing his craft, touring, taking care of himself. This is the house that Cash built. 2015, 8 tracks. Tracks or songs. Born for This, featuring Rich Homie Quan, Released in 2016. Song called Lil Baby. Released in 2016. Ran Up a Check featuring Lil Yachty. Again in 2016. Work.
My name is Ashley Puyol. I am the founder of a small company named Unwrap. I design my own wrapping papers. I started using Adobe well over a decade ago. I use Photoshop for photo editing. I use Illustrator for vector goods. I export it as a PDF, and boom, it's off to the printer.
Welcome to the Americas. 5